Okay, awesome. All right, we have a fun topic today. I thought I would change it up a little bit. And then also in August, which is tomorrow, I'm going to be really going deep into the purchase agreement, the listing agreements. I'm actually going to pull up the documents, and we're going to go step by step on how to fill out the documents. A lot of the stuff that I've been doing is more or less scenario type, kind of getting you to think a little bit. But August will be really the actual car form that we're going to go dive deep into the conversation. For people that know me and people that don't know me, my name is Simon Cazares. I am the team leader and the broker for KW South Bay, broker for Long Beach, and also the Valley office as well as the broker. So I really appreciate you all being on today's topic. So the fun topic, residential purchase agreement bloopers. Okay, bloopers are, can be funny, but it also can be stressful. Okay, when a real estate professional makes a mistake and an error, and it happens. Trust me, I'll be the first. I made errors, and the problem it can come back to haunt you, right? Just this morning, I was talking to one of our agents out of the Long Beach office. He represented the buyer slash seller. He helped them sell their property and then ultimately helped them buy a property. And they bought in an area in the hills. And apparently, the new owner received a knock from the fire department saying, "Hey, we're trying to find the previous owner. There was a report and he hasn't corrected or they haven't corrected the issue. And now the new owner's like, what is this all about? I don't remember seller ever saying any disclosures regarding the fire hazard section, right? So it's going to be a very interesting process. I told them to provide me with all of the information, the purchase agreement, the transfer disclosure SPQ, and also the actual report that the local fire department is requesting. And now the owners, the current owners, are like, wait a minute, am I going to be liable to correct any issues? And this is a quarter of an acre property, meaning it's not just a 5,000 or a 6,000 square lot. This is almost 35, 40,000 square lot property. And it's adjacent to other properties as well, even though the house is situated, but the actual lot is kind of a curve. And then it's adjacent to other property owners. So they may be responsible to trim down and ultimately, obviously for purposes of preventing fires. So it's going to be a very interesting, and he's like stressing out about it. And I told him, look, we'll get to it. We'll see how we can navigate that. So today we're going to discuss the mistakes that cost agents their deals, deposits, commissions, and obviously licensee as well, right? How many of you have submitted an offer without reading every single page? Okay, thank you. Yeah, you know, I'll be the first too, And once you get to a certain level, you tend to get a little complacent, and you think you know everything and you rapid fire go through it. And that's where you sometimes make the mistake. Okay, so you got to be mindful and careful when looking at, especially when you're receiving documentations from a seller or receiving documentations from a buyer, because if you miss something, okay, most likely your clients are going to miss it too. And then you and your clients may have agreed to something that the seller was not intentionally wanting to agree to. This is why it's very, very important. And see, what has not helped us and has helped us is DocuSign, right? Sending paperwork electronically. All they have to do is click, 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 initial signatures, initial signature dates, and all that, right? And we bypass all of the other relevant stuff, right? Instead of taking the time to actually thoroughly look at what is added, what is removed, what are the time periods, what are they asking, right? Because it's kind of a storytelling. And this is where you have to be cautious and be alert at the same time that before you send it out to your clients, make sure you're proofreading it. Make sure you're listening to everything that your head is telling you is, have I thoroughly looked through everything? All right. So I'm going to go through some situations as part of today's segment and understand that it can happen to any of us. Okay. But also keep in mind that you can prevent it as well, right? And it could be the other way around. It may not be you. You might be very diligent and looking through everything. It might be the other agent. And how do you navigate that, right? So, how many lawsuits began with, I thought? Okay. Well, I thought we can do that. I thought that was signed. I thought that the seller saw what they were signing. Makes you think a little bit, right? This is why you're paid the big bucks, to help navigate that. Because remember, when this goes sideways, they're going to be pointing fingers. And who are they pointing fingers? Me, myself, and I, right? Because you're guiding them through that process. And it doesn't matter if you're working with the buyer or the seller, it just happens. So I'll try to rapid fire. There's about 25 different bloopers, one contract, endless exposures, right? So we'll talk about deposits. We'll talk about contingencies. We'll talk about vesting. We'll talk about possessions. We'll talk about disclosures and addendums that are part of the process, right? Because there's a lot of moving parts. And once you understand the initial process from A to Z, it's easier to have the conversation with the buyer. It's easier to have the conversation with the seller. And you're able to streamline the process because it's systematic. But it's when you're not certain, you don't know, you're not asking the right questions, or you're kind of just sugarcoating it and surface conversation. That's what gets us in a situation. So you got to be mindful and also protect yourself. All right, so let's talk about the number one, the purchase agreement, right? So typical purchase agreement, right, is, the price, the deposit, the finance, the occupancy, if they're uh, taking possession with the tenant in place, is the seller going to stay in the property for a certain period of time? Is the buyer buying the property as its own primary, or are they buying it as a investment or as a second home, right? The close of escrow, is it 10 days or is it 30 days? There was one instance many years ago, one of the agents accepted an offer. It was a cash deal. And for some odd reason, they missed everything, and the seller needed at least 50 days. 50 days. They needed about 50 days. Not that they wanted a 50-day escrow, they wanted to do, a 30-day escrow with a seller in possession for an additional time, right? To stay, which was another 25 days on the property, right? If you do the math, 30 days plus 50 is 20 days, I should say, right? Um, that's what they wanted. So they wanted to stay in possession because they were buying a property, new construction out of state of California. So that's what the seller wanted, and the agent knew that. So when an offer came in, the offer came in cash. But the thing that they missed was that the buyer wanted possession in 21 days. And I don't know how it happened, but it happened where they accepted, thinking that they had the language in there of a 30-day escrow and then a seller in possession for another 20 days for a total of 50 days until their new home was ready to move in, right? And they asked for that additional 20 days. Not that they needed 20 days, but they also wanted that safe haven enough time that if they didn't have their possession of their new home, they wanted that time period, right? Well, what they missed was that the buyer was in urgent need to move in. They were starting a new job. They were also moving out of state to California, and they needed a place because he was starting his job here locally. And so someone dropped the ball. And the buyer says, nope, I am not going to give you 50 days. I am not going to give you the 20 days in seller in possession. We agree to 21 days. That's what the contract says. Okay. And, the listing agent felt super bad. The seller was frustrated. The buyer was also frustrated as well. Everyone was a little disappointed. How did that happen? How did something so small, everyone was super excited that, it was an open escrow cash deal, but someone failed to look at the documentation on what was actually asked for. And it happens, ladies and gentlemen. You can be in the heat of a conversation and you send something by accident. Also, the seller believed and just click, 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 sign, 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 accepted the offer because it felt really good. It was like, yeah, this is great. But down the line, they realized that they had made a mistake, that the seller needed time. So ultimately, we it ultimately became a resolution, but not the resolution that either party wanted. Okay, because one wanted the property in possession after we recorded within the same time that it gets recorded, and that's 21 days. Seller wanted the time because they were going to be with no home. Their home wasn't finished yet, right? So they compromise, and we ended up doing, I think, like 35 or 40 days. Okay. We still closed in 21. Okay. We still closed in 21, but then we gave the additional time frame for the seller to stay in possession. And then ultimately the seller had to go and vacate the property, because again, the contract is the contract, and someone made a mistake in making sure that there was a adequate language and or understanding in how these documents work. So shame on everyone that didn't see it on the seller side, and that can happen, right? And the good thing is we ultimately made it a win-win, but it can happen, right? So, in essence, if one page is wrong, then, most likely there's other stuff in the paperwork, right? Can be wrong too. And right now, ladies and gentlemen, the purchase agreement contains 16 pages. 16. And this is just the RPA. Okay. So be mindful, be careful, understand that any little error can be a big issue, big issue. Because what if the buyer says, nope, not going to do it? We agreed to 21 days and I'm moving in. My moving company, right, could be a 50-foot trailer is hauling stuff from Arizona or from back east somewhere, right? And they're coming and there's nothing you can do about it, right? So, in essence, remember, look at every piece of the documentation. What am I missing? And tell yourself, what should I be looking for in these documents, right? Because one little mistake can open up a can of worms, and now someone would be probably writing some check. Number two, wrong vesting. Okay. Now, it's very far and few, and this is one thing that you can definitely correct, right? But the wrong way is John Smith, right? When there's an actual trust, right? So the wrong way versus the correct way, right? The correct way is John Smith, trustee of the John Smith Revocable Trust, right? So also, like the corporation, you represent a buyer, and the buyer has a corporation, and they're asking that they want vesting under the corporation, and it's very common, especially for investors, flippers of that nature, to ask to be put on their corporation, right? So make sure that you're getting the articles of incorporation. So know exactly how they're vesting title, right? Now, the good thing is there's a lot of people that see this. It's not just you and the buyer. Thank you. Appreciate it. It's also escrow. It's also title. It's also the other agent, right? So there's a lot of people that see this, right? But the correct way is ask the questions. It's ABC Investment LLC, or is it just ABC LLC? Because there's a lot of ABC LLC, and one little error can alter all of this and cause some issues down the line, right? And that goes also for probates, that goes for trust sales, LLCs, corporations, and even power of attorney. Make sure that you know who is the right person vesting on this and ask those questions as well. Because if you don't, it's going to either delay the process, and now it can delay the closing as well, right? If you have a 25 or a 30-day escrow, and now there was an error that was made, that can set back the whole entire time. You may be looking at a couple days or a couple weeks, and that puts a lot of strain and frustration on the buyer and the seller. So be mindful, ask the right questions, and then ask for the proper documentation so you know exactly how they're vested. Most of the agents are really good at checking and identifying and asking those questions, and others are just very surface and do not ask the right questions, and now we have to alter, and now that can also delay the initial process. All right, so let me ask you a question. Who owns the deposit? Okay, who owns the deposit?
It's neutral in escrow.
Say again.
It's neutral in escrow.
Yeah, it's pretty much, I mean, some will say, well, it's the buyer's money. It's really their money, right? In essence, it's the buyer's, right? But as soon as it goes into escrow, okay, and that's the key, as soon as it goes into escrow, really no one owns that deposit yet. Okay. Yeah. Yeah. Once it goes into escrow, this is why it's very important that if you're representing the seller and the buyer hasn't deposited the earnest deposit, that's a problem. I'm going to share a story with you. It's actually happening right now as we speak. It's one of our agents in the Valley. She represented the seller. They accepted an offer from this wholesaler. All right. I know Joanna and Steve are already going 100 miles with this. They accepted an offer. It was a cash offer, close in 12 days. And this is a little over $2 million deal. So it's not small potatoes. It's a big deal. It's a big price. 2 million. And they divulge and they disclose all this that, yeah, it's a wholesaling company. It was two individuals, two different entities. Okay, two different entities, which was a little ironic, and just it took me a while because this was just brought to my attention. I didn't know all of the beginning. I usually have to play the detective, trying to figure out this investigation, like, okay, what happened? Because I'm not privy to know exactly the beginning conversations, the negotiations. So my job is to try to put this puzzle together, right? So they brought it to my attention, and everything just did not resonate well with me. It was just like, wait a minute. And in the back of my head is like, what? 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 But it happened. Now, it's still in escrow. And I told you it was a 12-day escrow, 12 days. They released all contingencies. Now, one thing that I failed to tell you, there is no deposit in escrow. No deposit. We're over a month into escrow. Makes you think a little bit. What happened? How did this happen? But it happened. You know, apparently the buyers were giving them the song and dance and bringing all kinds of excuses and delaying this deposit. How do you go 30 days, without a earnest deposit? Look, I'm not blaming anyone, okay? That's not the intent today, right? It's just for you to understand the elements of what could transpire, right? Because remember, I don't know the whole story. I don't know what was said. Okay. And I have to also take it back to the buyers for not doing the right thing as well. And it happens. Look, I've been there. I know exactly. Have I made mistakes? Absolutely. And I go back and think, gosh, I could have done that a lot different. It's happened to properties that I've bought in, and it's like I could have done that differently. But you learn from them. And then you know exactly what not to do, right? So now is we're trying to get this buyers to sign off on the cancellation. There's no way. These buyers are not. They're trying to find an end user to come in to buy it out. And that was kind of the delay. They kept saying, yeah, we have someone and this, that, but we need this, all these different situations. And unfortunately, the seller also has a little bit to do with it because the seller was also allowing this situation. The other thing that I failed to tell you is that the seller is in a foreclosure, and the foreclosure is coming up very soon in August. Yeah, yeah. Okay. Say again.
Ain't this fun?
I love it. Yeah, this is where you guys put me to work. On top of my other stuff that I do. But yeah, but here's another thing, under paragraph 5A, late deposits received after the deadline might be rejected and could jeopardize the offer, right? Remember, an offer is submitted, offer is accepted. What is the time frame that the buyer has to put in the earnest deposit into escrow? Yeah, 3 days. Good job. Yeah. 3 days. And what happens if the buyer doesn't put in the deposit within 3 days? Yeah, you send what's called a notice to perform. Okay. And if the buyer doesn't perform, then the seller has the right to cancel and move on. Put the property back on the market, find another buyer, and close with another buyer. Okay. Now, I'm not saying that this scenario is right or wrong, okay, but it's a scenario that I want you to be mindful that do the right thing as you're navigating and then ask for assistance. We're all here to help. We're all here to assist in navigating this. And we don't know what the buyer did. And then the buyer yesterday sent this really ridiculous email, really in telling their position and why they doing what they're doing. It just didn't make any sense. So I knocked it immediately, sent a response email saying, no, you guys did wrong. You guys need to sign this cancellation and let the seller put the property back on the market. That's what we needed in order for the bank to give us the necessary extra extension to sell this property. But we need someone to cancel. So ultimately, the seller finally, and he was stubborn. It's an older gentleman, was stubborn too. And I talked to him. He must have been, I don't know, in his 80s or something. But he was stubborn as heck yesterday. And it's like, man, okay. Um, he tests me. But it happens. Okay. Wire fraud. Excuse me. Yeah, wire fraud. Wire instructions could be. It's happened here to some of our agents too. Thank goodness, and it hasn't happened in our escrow companies, but agents that represent their clients wire money into escrow. One of our agents client wired like about $50,000, $60,000, and the company got compromised. The escrow company got compromised, and they lost millions of dollars to fraud. where ultimately the FBI did an investigation and shut down the escrow company. And the money, again, is still missing. You know, now there's some type of insurance, but trust me, you're not going to receive the money immediately. And if you're in escrow, think about this for a minute. You're in escrow and something happens with this escrow company, that stops everything. But remember, your money is tied in this. There's a lot of moving parts with this situation. We ultimately had to pull that escrow. It's still a pending situation. They did say that the state was going to step in and help navigate, returning of some. They didn't promise all, but some of the money back within the next, 60, 90 days. But what happens to the escrow? What happens to the buyer? What happens to the seller, right? That's a very sticky situation to be in. Ultimately, the buyer and the seller understood the issue and ultimately pivoted and opened escrow with another company. And the good thing is the buyer had the reserves to put a smaller deposit to still make this because they were still anticipating the money from the previous escrow company. Somehow it was able to work, and they were still able to sell the property. And I think at this point now they were able to collect some of that money that they lost during this fraud. So keep that in mind. Uh, Bad funds, no refund deposit unless otherwise agreed in writing. Deposits under paragraph A are non-refundable, right? So remember, there is no non-refundable, right? There isn't. And if you put language like that, I can argue my position and says, no, it's not a position of non-refundable. You got to go through the motions of knowing how it works, because that's why it says that who owns the deposit? No one. It's in a trust with the escrow company, and they don't own it. But buyer doesn't own it anymore. And the seller doesn't own it until we have instructions of what happens, right? If the deal successfully closes, then obviously that money goes towards closing costs and down payment. Um, and if the deal doesn't close and it ultimately cancels, we have to have mutual cancellation, right? And then what is the instructions that is provided to the escrow company? Is the deposit go to the buyer? Does the deposit go to the seller, right? And that's where a dispute may happen. And if there's not a meeting of the mind, that money will sit in there for a very long time, very long time. And I've had situations where they threaten, well, Simon, you're the broker. You should know better. You should do the right thing. Listen, this is not about me. It's not about the brokerage. Heck, it's not even about the agents. It's about the buyer and the seller. You guys have a dispute. And when there's a dispute, we step back. You guys need to iron it out between one another. That's why the purchase agreement has specific language. When there's a dispute, then there's a process called mediation. There's a process called arbitration. And these are angles and positions to come to a resolution. Next month, I have a mediation that I have to be on one of our agents as well. And really, what it is, it's a mediator listening to both sides of the story, trying to compel reasoning for both to come to an agreement. It may not be the black and white of the purchase agreement, but they have to come to some resolution. I can argue the fact, well, the buyer released all contingencies and the seller is entitled to the deposit in escrow. Black and white. But if the buyer disagrees with that and says, no, 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 I don't agree to that, okay, there's nothing that escrow can do to release the money to the seller. Now you guys have to go and get a referee and basically dispute it between both of you. And the mediator's number one priority is to come to a conclusion immediately. Okay. It's not about, yes, the money, it's all yours. Yes, the money is all to the opposing. Is the conclusion is we have a dispute. There's a $35,000 deposit. The purchase agreement says this. Are you willing to give some to the seller to start the dialogue or the conversation? Buyer says, nope, I want my full deposit back. I don't want to give anything. I want my deposit back. Then you go back to the seller is, hey, I know the provision on the purchase agreement says about buyer breaching the contract, buyer releasing all contingencies, buyer failed to perform, we sent out a cancellation, and yeah, there's damage. Okay. Are you, seller, willing to take something less than what's in the escrow? Again, if there's a $35,000 deposit in escrow, right? Now we're trying to weigh out what's the best for both parties. Seller may come back and says, look, as long as they give me half of the deposit, then I'll release the rest of the money, right? Okay, that gives me something to work with. Now I can take that. It says, hey, buyer, I have some great news. The seller is willing to release you from this contract and this obligation, but they're asking for half of the deposit in escrow. And the buyer thinks about it is, okay, so it's not the whole 35,000 or 30,000? No. Okay, well, I don't want to give half. I'm willing to give $5,000. I want the rest of my money. 5,000. Something for me to work on. Okay. Meteor goes back to the seller. Hey, I got some great news. Great news is the buyer is willing to give some money. All right. How much? 5,000. 5,000? Are you crazy? I said half. Well, that's again part of the mediation process. What would you like to counter? Okay. Let's do. If they do 10,000, I'm good. 10,000. Great. Okay. Go to the buyer. Hey, I got some great news. The sellers do not want half. Now they only want $10,000. $10,000. I only said 5,000. No, I cannot do 10, but we'll do 8. 8 it is. I go back to the buyer and ultimately the back and forth until we can come to a resolution. At least we have dialogue. And now both the buyer and the seller agree to 8,000. Seller gets 8. The remainder of the deposit goes back to the buyer. Well, wait a minute, Simon. Wasn't the seller entitled to the whole amount? Everyone say yes. Absolutely. But remember, escrow is in a position as a third party neutral to go by the instructions of both. Remember, if both agree, it doesn't matter what the contract says. You with me?
Yeah.
Now, both positions can be stern and says, nope, I want the whole entire deposit. I've been damaged. I replaced the roof. I repaired the AC. I did this. I did that. I'm entitled to the full deposit. I get it. But until the buyer comes to an agreement, that money will stay in escrow. You understand? Yeah. So it's not always the black and white. It's really between them to come to a resolution. Now, our job as real estate professional is to not put yourself in a legality and say or promise, yeah, you're going to get the money. Yeah, yes, yeah, that. Because then they can go after you for misrepresentation. You told me, Simon, that I was going to be able to get that $30,000 deposit. Okay. That's the minute that you compromise. And now we have to escalate and tender into our errors and omissions insurance, ladies and gentlemen. And we do not want to. Errors and omissions insurance is there to protect us. Yes. But remember, it's like automobile insurance. We have it, but we never want to be in an accident, right? Because what happens when you're in an accident is your fault. You have to pay a deductible. And the more insurance claims we have, our premium goes up. Every year, The office, myself, and Linda, the MCA, we talk about what claims are currently pending, what claims may be a tender, and I hate it. I really do. But it's just the nature of it because our job is trying to minimize every year, but it just seems to go up. So I hope that kind of gives you kind of a nutshell of how liquidated damages work, right? It's not always as it states, right? I mean, the end result, and most people will comply to it, most will. But a lot of people that know and understand, they can sit there for weeks and months without anything. I have another situation where we ended up closing with another buyer, and there's still money on a deposit that the buyer hasn't claimed it. They didn't want to release it to the seller. I tried to mediate the situation. I was back and forth, and I even says, look, the seller is willing to even take 50% and release. And the buyer says no to that. What can I do? I can't force the buyer, I can't force the seller to do what the contract says. It's really up to them. And if they don't do anything, guess what? That money sits in escrow until eventually, when they're ready to release it, it goes to the state. And now the buyer will have to dispute that with the state. And some big investment companies know that. After 3, 5 years, that money goes to state. Now they just have all of the documentation. They go to the state, and try to argue for that money. Okay. I don't know the initial process, but it would be interesting to find out what happens to the money that eventually goes to the state. How can someone go after that money? Question?
If there's a dispute with the policy, sometimes they're saying, well, we have to hold that money for, years and years and years, we're gonna take X amount like out each month. This. Sure.
Take out each month what? Money to the state?
No, they'll take out, so it's a fee on that money.
Mm, yeah. Interesting. I don't know, but that's a good question. I'm going to find out for you. Yeah, I'll find out. I don't think so. I don't think that's the practice. But that's a very good question. The question for people that didn't hear on Zoom is certain escrow companies, if there's a dispute, we cannot come to a resolution, there's money. Escrow will have a servicing fee each and every month that is tapping into the deposit. Obviously, it has to be agreed upon, and it's probably part of the escrow instructions, right? Saying, hey, if there's a dispute regarding this and no meeting of the mind, each and every month that this money is held by escrow, there's a servicing fee that is going to be deducted. And that might push the buyer and the seller to come to a resolution, right? Especially $200 per month. That's a lot of money in a year, right? So, yeah, that's a good point. I'm going to put a note to that, and I'm going to ask Pacific and ask them if they have that specific language in there. Good point. Remember, the deposit isn't automatically forfeited because someone says, yes, so, right? No,
Simon,
it's not. Yes.
just going back to the previous paragraph or previous statement you said, that the home got sold to the next buyer without the previous escrow, the money being released. If I understood correctly what you said, um, my understanding was, and again, I could be wrong, that until the money is completely settled with the previous transaction, a seller cannot sell it to another buyer unless everything is settled with the previous transaction. Am I wrong on that?
You're right and you're wrong. Good point. Question here for the people in class. He says that, hey, wait a minute. I was under the impression that if we have a dispute and escrow hasn't released or haven't closed the earnest deposit, does that give the seller the right to now go with another buyer and ultimately close escrow with someone else? He was under the impression you cannot do that. So here's kind of the general point to that. So if both, meaning both the buyer and the seller, send a cancellation, right? Let's say that the buyer sends the cancellation saying, I, the buyer, are signing off on the cancellation and either returning the money or partial of that money, okay? And it's sent out to the listing agent and also the escrow company, right? But we don't have the seller's signature just yet, right? And let's say that the seller says, I don't agree to the buyer getting the money back. The buyer released all contingencies, right? We want the deposit full, right? The whole 30,000 as an example. So the listing agent will do their own cancellation and send out a cancellation. So now we have two cancellations, one from the buyer, one from the seller, right? Now the intent here is that we want one cancellation signed by both, right? If it's releasing, partial, or everything back to the buyer, it doesn't matter. That's what we want, one clean count or cancellation, right? And I'm sorry that I'm blocking you. Okay. One, but sometimes there's not a meeting of the mind. The seller wants to cancel, the buyer wants to cancel. So once both sign a cancellation, send it out, that's a cancellation, in my opinion, signed and executed by the seller, signed and executed by the buyer. The question is still the money, because there's a dispute between the money. But in my opinion, you've canceled. So with that, you have the right now to put the property back on the market, negotiate terms with a new buyer, and close with a new buyer. Okay, because we have cancellations between both. Okay, now the question is, you still are going to disclose because again, it all depends on the circumstances. Now, the question is, what if only one cancels? I'm the listing agent. I send the cancellation. Buyer never signs it. Does that give the right to the seller to excuse me, does that give the seller the right to now put the property back on the market? We don't have the buyer's cancellation, but we know that the buyer forfeited or breached the contract, right? And we have paper trail to put us in that position. We send the notice to perform and the buyer didn't perform. We have the right to cancel, but we didn't have the buyer's signature. Does that give the seller the right to put the property back on the market? The answer is yes. It does give the seller the right because we have documentation to prove our position. If this goes sideways, right? If this goes sideways and now the buyer's disputing, because the buyer can come back and dispute this and says, no, I never canceled. You cannot do that. Now, we're not going to tell the buyer that, we open escrow and all that stuff. We're not going to divulge that, but you still have to disclose that to the new buyer that it's still subject to cancellation. And then once we know that the deal with the second buyer is going to close and we have reinsurance, then we can go back to the original buyer and says, look, we're going to try to negotiate this. I know that we wanted the full deposit, but now we're just going to release you and cancel and just give you the money back. The seller has that right to do so because you're still having that lingering position that buyer one has not officially given us instruction to cancel because they didn't sign it or they didn't propose their own personal cancellation, but doesn't stop the seller from wanting to put the property back on the market, find a new buyer, and ultimately try to close the deal. Okay? Because the concern here is the buyer wanting to come back, the buyer seeking and hiring a real estate attorney, and then possibly putting what's called a lease pendants against the property. But that's very far and few that it happens only when the buyer is pissed that the buyer is doing something crooked or shady and did it under them to try to, because they wanted a higher price. then I can see the argument here where a buyer will ultimately try to defend their position and says, I did not cancel. I'm within my rights. Okay. But once you have both buyer and seller signing a cancellation, even though there's still a disagreement regarding their earnest deposit, the seller can ultimately close with another buyer. Does that all make sense? Okay. Now, again, going back to the question is, well, wait a minute. What if we didn't get the buyer's blessing and it's still lingering? Again, what I mentioned is then you want to go into the negotiations because you don't want this buyer to come back and says, well, we never canceled. We wanted this property. And here's the proof, right? And now the seller sold it to another property, another buyer, right? The essence of the situation is a little bit different. One is something might have happened, right? We don't know. Maybe they had a family emergency, the buyer, and they had to leave the country and they just failed to tell us, right? So many situations, so many scenarios that can happen. But the essence is once one party or the other party signs on the cancellation, that gives already the position to ultimately put the property back on the market. Okay. The only time where it gets a little sketchy, and I would say, you know what, we don't want to just yet, put a property back on the market. And it's when we know that the buyer is in the right. And that's why when I ask questions, I get a better understanding of where we stand. Well, it looks like the buyer is still within their right to do so. It just doesn't feel that the seller is giving the buyer the opportunity. Just because they're upset doesn't give them the right to cancel on them. And I've seen situations like that happens. So be mindful of that. I hope that kind of answers your question. And you may have to open an escrow with a different escrow company too. That's one thing some escrow companies have a policy. If they have an open escrow with the current seller, they may not be comfortable taking on another escrow with the same seller on the same property. You may have to take it to another escrow company and start fresh. Okay. Questions? Did it all make sense? Joanna.
Just quickly go back to the wire fraud, because I know that wire fraud is so big in this industry. Is there anybody working on trying to figure out like how to stop that, or just is there anything in the pipeline?
Well, I believe they've gotten better and better at it. 3, 4, 5 years ago, it was a lot different than what it is. I know that escrow companies are more vigilant, they're more proactive, they have systems, they have layers of protection. They're also utilizing artificial intelligence to detect scam emails and make sure that it is, because one little letter, one little character can be someone else interpreting a buyer, seller, or a real estate agent, right? So now escrow companies are being very diligent in their approach and how they're identifying, potential scams and intercepting these before it ultimately goes to the wrong person to wire money to an account that is not even in escrow. But is it still happening? Yeah, it's still happening. I don't see it much with the big companies. I know Pacific Coastline Escrow. They are like state of the art, making sure that they have all of their ducks and rows, and they're really, really proactive in their engagements and making sure they pick up the phone, they call the buyer, they say, please repeat the routing and account information. And they're just not just an email. They are proactive in their conversations before they send wires and all that stuff. Yeah. Yeah. This is why, we're vesting people, because we don't want your clients to be in a predicament in a situation. And we'll go into seeing their ratings, we'll go see of complaints, we'll see their licenses, are they bonded, are they insured? Because, you go because they have good rates, but have you looked at their history as well? That's why you want a reputable and a company that has all of those in place. my opinion. So good questions. All right. So blooper 4, checking no loan contingency. Buyer is saying, right? I do not need finance as a contingency, right? So remember, if the buyer is going cash, typically what happens is the contingency of loan is release. Okay. So can a buyer check off loan contingency even though they have a loan? Let me repeat the question. Can a buyer release loan contingency even though they're getting a traditional loan? And that could be conventional, FHA, VA, seller finance. Okay. Can they do that? Can they release the contingency? The answer is yes, they can. Yeah. Basically, you're telling the seller, hey, I'm guaranteeing one way or another, if I'm releasing the loan contingencies, I'm going to find a way to, get the loan necessary or the finance necessary to close the deal. And I might say go traditional loan, but I might have reserves or money to close this cash. But I don't want to tap into all of my funds, right? And you may go in that direction or vice versa, right? What if you go all cash? Can you then pivot into stating, I want to go traditional loan, but you release the loan contingency. Can you go from cash to now a loan? Yes, you can. How many people say yes? Huh?
Both parties agree.
Okay, good. Good answer. Yeah, as long as both agree to it. It's not something that I would recommend, right? Because the seller may say, well, I only accepted your offer based on you going cash, and you say you can close in, 12 days. And now you're going a traditional direction with the loan. Now they're asking for another 10 days or 15 days or 20 days. But that's not what we agreed to, right? So the seller may agree to it, doesn't necessarily mean they have to. As long as it's within the time frame, then it's perfectly fine to do so. But don't go doing that saying, I'm being clever here. I'm gonna go cash, but I know that they're really a VA with no money down. That's a no-no. You're going to piss off the listing agent and they're never going to do business with you ever again. They're going to see your name, Simon. Oh, no, stay away from Simon. Okay. Because again, it's the delay, right? But again, if buyer and seller come to an agreement, then it's perfectly fine. But you can also stand your ground. This is not what we accepted. As long as you can close within the time that we did, it's on you, buyer. But if you don't, we're going to cancel on you. And if you released all contingencies, we're going to go after your deposit.
That cash that you showed.
That's right. That is right. Yes. Removing loans and removing appraisal, right? So loan removal, it doesn't necessarily also remove appraisal contingency. Let me ask you this question. If I submit an offer and it's an all cash, price is $1 million, I'm offering $1 million, and it's a cash deal, can I still retain my appraisal contingency?
Yes.
Okay. So I can keep my appraisal, even though it's cash. There's no red tape, no finance, but I still want to retain that appraisal contingency as part of okay. Yeah, absolutely. The answer is yes. Even cash, you can still have an appraisal done because you don't want to pay for a property that's overpriced, right? And I said the stipulation here is I'm going all cash, but I still want to get an appraisal, make sure that I have some negotiations if this property is not worth what I'm offering. Yeah, because what if the property comes in at 975? That's 25,000. That's a lot of money. So yes, the answer is on a cash deal, a buyer can retain the appraisal contingency. These are
Simon,
two separate.
a
Yes,
question on that.
yes.
On the appraisal, so when it gets done,
And you want to now revert back to the 25,000 difference. Uh, what do you do then? Do you fill
I
out?
I have I think I have a next slide on that.
Oh, okay, thank you.
Yeah, we'll talk about the just the differences. I'm not sure if it's the next slide, but I know it's in one of the slides here. All right,
Excellent.
so these are separate contingencies, right? Can your agent explain the differences under oath, right? And basically, not that you're going to go into court and only if it's something fraudulent, right? And I had to only once be an expert witness. And this was probably, I want to say 15 years ago. Someone was doing fraud. They tried to defraud the seller. So I was part of that court hearing. I had to testify as an expert witness. Not fun, because that's prosecution, that's jail time, and also sanctions and money as well. So make sure, your clients and us as real estate professionals are not doing anything to compromise our real estate license. Because once that happens, your license is gone. All right, let's continue. I know we're cutting it close, so if you have to leave. I completely understand. This whole entire segment is going to be recorded. All right, number 6. This is the one, appraisal gap. Okay, so appraisal gap in insurance. So if the acceptance value is not waive appraisal, right? So meaning is that yes, there is a section on the purchase agreement that allows you, the buyer, to come in with the difference. That's what we call an appraisal gap. And how it works is that if you know that the property might be overpriced, but your buyer is still okay to take on that risk, there's a section that allows the buyer to come in with the amount necessary if it does come in with a certain value. For example, if the offer is $1 million, an appraisal is done, and the appraisal comes in at 950, but you put an appraisal gap that the buyer will do up to 975, what does that mean? If the appraisal came in at 950, you made an offer of $1 million, the buyer put a stipulation gap of 975, what does that mean?
Yeah, 25.
Say again?
Yeah.
Yes, thank you. Yes, you still have a $25,000 gap. The buyer is willing to come in with a 25 gap from the $1 million to the 975, but that still gives us another $25,000 gap because remember, the appraisal came in at 950. Now, what does that mean? Is that an exit for the buyer? Yeah. So as long as the appraisal contingency is in place, you can do 3 things. You can ask the seller to drop the the purchase price down to that amount, or the buyer and the seller can come to some type of agreement, or the buyer has the right to back out if there is no agreement from the seller. The seller may say, nope, I am not going to reduce it down to 950. You got to come in with an additional 25. That means that the buyer would have to come in with $50,000 to make this deal work, right? And the buyer says, no, that's why I put a gap appraisal on it for a maximum of 25,000. Now, 25,000 is not that much of a deal. I think you can work it out. I don't think you're too far. Now, when you're in the 50s, 60s, 70s, or even $100,000, well, the listing agent has a problem on evaluating homes, first and foremost, right? But it's also your job to be thorough and run some comps, especially in areas that you think, yeah, I think this property might be overpriced for the area. Run numbers to see, because you don't want to go 17 days into a escrow to know that, the numbers are so way off that, you're $100,000 in difference in value and the seller cannot sell it for that amount and won't sell it for that amount, but you just wasted 17 days on an escrow that wasn't going to close anyways. Okay, so be mindful and cautious about this. Insurance, okay, California fires, the fair plan, the high fire zones, uninsurable properties. Some homes may have no coverage. With all of the Palisade stuff happening right now, condominiums right now, we're having a difficult time trying to get insurance. Very, very difficult where deals are falling apart because there's just insurance companies are not insuring the homes in the condominiums. So it's definitely something that you need to be again mindful as well. Buyers should investigate insurance immediately. So, the first thing that you as a real estate professional need to be letting them know is like, hey, you want to start now talking to your insurance carrier to find out once we find and identify a property, call and say, hey, here's the property address to a property we're looking into making an offer. Is it insurable? And if they give you the green light, fantastic, then you're good. Don't be that buyer that waits till the end to try to find and shop around because you may get one of the worst insurance with the highest premium, but you have no choice. You got to close, or you may forfeit losing your earnest deposit. So you may have to take the higher insurance premium, which if you would have been proactive in the very beginning, shopped around, finding the one that meets all of your coverage, then it avoids delays and ultimately frustrations as well. But removing contingencies too soon, right? So again, this is why we have timelines, right? 17 days for this, 5 days for that, 3 days for this, right? Be very careful. Buyers should not remove contingencies without receiving all required reports, disclosures, and information. So if there's something that you haven't received, then don't go releasing contingency because the seller and the listing agent are forcing you to release it. Hey, I still haven't received the TDS. Hey, I haven't received the SPQ. Then that's your shield, that's your protection to allow you the time necessary because you're haven't had a thorough fully disclosed information about the property, and it's perfectly fine. Why do agents still remove contingency before reviewing everything, right? Now, and these are for the individuals that, it just kicks me in the rear when I see these investors, especially these novice investors that don't know what they're doing. They go in there thinking, oh, I'm going to release all contingencies, right? And then when all goes sideways, now they're pedaling, trying to get their earnest deposit back. Well, wait a minute, you released all your contingency. I have no pity for investors. I have not, because they're always trying to find loopholes, ways to get out. They're charming, convincing, and agents sometimes fall trap to all this stuff. It really pisses me off. And I'm just being honest in how I feel because I deal with a lot of these knuckleheads that just do not understand how it works. And I'm talking about investors. So one deal, it was a prime situation. He was arrogant and he thought he knew more. And when I stepped in, he thought he can outsmart me. And ultimately, that was not the case. Right, literally, and I don't know if I should say this, but I literally got a call from his wife begging and pleading that, hey, please help us do the right thing. This is not right. Wait a minute. You guys came in strong here, released all contingencies, and now the buyer is not really in a position to really buy this place. So again, just be mindful about these situations and be proactive. And again, that's again playing offense and defense. If you represent the buyer or the seller, know your positions and how contingencies work. Contingencies are a safe haven. They're a layer of protection that protects the buyer's deposit. Every contingency you release, it's exposing the buyer's deposit. Once the buyer releases everything, there's no going back. I have another mediation that I have to go on because the buyer released all contingencies. The listing agent and the sellers say, hey, you released everything. We're going to, we want to go after the full deposit. The buyer says, well, this was the agent. The agent told us to release thinking that we were going to get the loan. They unfortunately were not able to get the loan. And now it's like we have a $18,000 deposit and I'm scheduled to go on a mediation on that situation. So, never fun, right? Never fun. Be careful and mindful, and make sure you're receiving all of the reports, you're reviewing all of the disclosures and any information before you allow the buyer to release. Now, I hear this quite often. The buyer always says, "Well, what would you do, Simon?" Okay. So never put yourself in an entrapment where they're telling you what they should do about releasing their contingencies. Mr. and Mrs. Buyer, in all due respect, I completely understand. I'm not buying this property. My money is not in jeopardy here. You got to let me know how you feel. And if you don't feel comfortable, we just won't. We'll ask for an extension, or unfortunately, they're going to send us a notice to perform, and we have only a certain time to release that, and the seller may cancel. I'll do my very best to try to negotiate and ask for time, but I cannot answer that question. And I won't answer that question. You got to let me know if you want to release it or not. Okay. Don't put yourself in a position and it says, well, I would, or yeah, I think we're okay. And then you have the buyer release it and the deal doesn't go through. We may be writing a check. So be very careful about that. All right, investigations and contingencies, right? So again, what agents order, right? Inspections, termites, and roof. But really what paragraph 12 really talks about is there's more than just a home inspection, a termite inspection, and roof. There's a lot of things that it talks about. One of them is insurance, flood, permits, environmental, zoning, HOA, any future developments. This is why we give you so many different disclosures, because there's a lot of information on there that the buyer has to make a sense of, okay, I know exactly, and I'm okay, and I'm comfortable releasing this as part of the condition. Because once that gets released, there's no going back. Okay, there is no going back. And I cannot say, well, I did not know. Well, a good agent is going to say, well, you released that as part of the contingency. You release that as part of your understanding. When you sign, you acknowledge, you understand, and you approve. So I can use that as an argument saying, I'm sorry, you should have read. That's what I said early on the slides, right? Does all agents read everything that they get in front of them? The answer is they don't. And that goes for experienced agents too. I've seen okay, you know better. Okay. But we go quickly because we have so many different things happening and we may miss one thing that may alter our position. Just be careful about that. All right. Blooper 10 and 11, as is and personal properties. Again, I mean, it's pretty common, right? Here it is. And it's a very frequent thing that I see quite often is as is does not mean there is no disclosures, right? And I think in the previous classes, I've talked about, how as is works, and that even though the property is sold in is as is condition, doesn't mean that the seller doesn't have to provide you with disclosures and material facts about the property. They still have to provide all of that. Okay. What it says also that the seller doesn't have to do any repairs, any credit, any concessions, or any price reduction just because your buyer is asking. Okay. Remember, this is where you have to be really good. And this is where I see most deals fall apart is during the physical inspection contingency period. This is where most deals fall apart. So no, if you can at least pass that hurdle, then you're pretty much 80% likelihood to close the deal. It's just getting through this period can be challenging. Personal property, remember, like ring doors, chargers, mounted TVs, those pool remotes, smart thermostats, garage remotes, all of this stuff. What is personal and what is staying with the what is staying with the property. Know and distinguish the differences between what is staying and what is not. So if you represent a seller as an example, and they know that they're wanting to take that refrigerator, tell them to get it out before you put it on the market. get the replacement immediately, so that way the buyer doesn't think that the refrigerator, that specific refrigerator, is staying with the property. Or if it's staying there for now because you don't have a place to put it, make sure that you're disclosing to the buyer, hey, this refrigerator in the kitchen will not be part of the sale. We are replacing it with this other refrigerator. We're putting that in writing. So that way the buyer knows, okay, this is not staying with the property.
Replace that refrigerator, or they can just.
Well, the new rules and regulations is that the property should have a refrigerator. But it all depends on the situation. Remember, everything is all negotiable. Now, most of your first-time home buyers, would like to have a refrigerator, but some of them really don't care because they're going to get their own refrigerator. So it really depends on the situation. Whoa. Sorry. Jumping the gun a little bit. Again, smart homes, all that. Cameras too, right? Are cameras part of the property? They're screwed into the properties. Are they considered personal, or are they considered part of the property, right? So it all really depends. Most people will probably remove them. Most people won't. I have a Brento, and I just left the cameras for the new buyer to use. I just removed all of my personal information, had them just redo it, and now they have cameras for themselves. But that's probably going to stay with the property if I ever decide to sell. So again, asking the right questions, right? Asking what is staying, what is not staying. And a lot of the stuff is very common sense. Credits, right? So it's not automatically added to the purchase agreement, right? So again, it's part of the negotiations. Everything is all negotiable, right? And if both parties agree, then we're good. Repairs requests, okay? So seller is not obligated. We talked about that again, right? That even though the property is being sold as is, the buyer can do all of their inspections, but you still got to ask the seller if you want something fixed, right? But the seller can come back and say, look, as much as I want to help, I'm not going to do it. We're not going to do it. The property sold in as is. If you want the property, great. You take it for what it looks and it is, or you have the right to back out of the deal. Again, it's your strong position there. I'm going to skip a little bit just so for the sake of class. Number 24 and 25, missing addendums and missing definitions, right? So a lot of the things, make sure, if the seller is planning to stay in possession, that you have the SIP, contingency removals, request of repairs, the sellers respond to the buyer's request, solar addendums, a lot of issues that we're seeing right now is solar panels. Are the solar panels transferable? Who's responsible if there's still a obligation on them, right? Is the seller going to pay them off, or is the seller going to transfer it and now the new buyer takes responsibility, right? Be proactive, get information, start the process immediately. If you know that there's solar panels, if you know there's HOA, start fast and quick, so that way there's no delays whatsoever, because this is what happens often is something is missing, and now we're scrambling as we get close to closing this deal. And the problem is now we have to extend escrow because now we don't have all of the documentation in place. Missing definitions, the purchase agreement has, again, at the, I think it's paragraph 23 or 28, it has definitions. I encourage all of you. A lot of your answers are on the definitions when it comes to acceptance, when it comes to delivery, when it comes to days, electronic delivery, what, stipulates, part of the incorporate of the documents that it's, written by California attorneys and otherwise agreed, right? So when it says otherwise agreed, it's an interpretation that it's not set in stone, it's not black and white, it's an alternative. Hey, I can tell you that this offer says $1 million, right? That we'll close in 30 days. But then you and I otherwise can agree to a certain price. Listen, I thought about $1 million. but I thought about it. I only want to give you $950,000. And if you agree to it, it's otherwise in a different approach and a different agreement, right? So that's kind of the dynamics of the agreements. The RPA isn't 17 pages because it's CAR likes long contracts. It's 17 pages because every paragraph exists because other realtors make that mistake. Think about it. And I'm going to point fingers at Joanna and Steve. When you started, Steve, how many pages was your purchase agreement?
1 page of the contract actually is 1/2 of 1 page.
1 page and half of it. It's a lot had to do where you had to write a lot of stuff.
Well, it's a lot to write on 1/2 a page.
Yeah, Joanna, how many when you started your career, how many pages do you remember?
8 or 10.
Yeah. Yeah, same here. When I started my real estate career, I think there was like 5 or 6 pages back in the early 90s. So we've come a long way. And guess what? 10 years from now, that's 17. And this is just the RPA. That doesn't even include all of the addendums, advisories that is all incorporated. This is just the RPA. Okay. Trust me, 10 years from now, there's going to be even more stuff. So be cautious and know and understand because twice a year, right? There's always changes to the purchase agreement, to the car forms, right? It happens in June and it happens also in December. So
That's why I always said if buying the house was only about price, then the contract really would have remained just 1 page long.
that's right.
Buying the house isn't just about.
Right. So the broker's top 10 review. So we talked about the vesting, APN, corrective property, finance, deposit, contingencies, addendums, credits, included, excluded, timelines, and read every page before sending, right? So making sure that if you receive a counteroffer, are you reading and really speaking of what it means? Because if it doesn't make sense to you, it's probably not going to make sense to your buyer as well. So get an understanding. If that means pick up the phone and call the listing agent, hey, on the seller counteroffer, thank you very much for sending it to me, but I'm just not clear on sentence number 2. Can you clarify that? Oh, okay, that's what it means. Okay. Now you can interpret that when you're talking to the buyer, you may have to tweak it and send them a counteroffer that adjusts this because even though the listing agent said it this way, but it sounds different here, and you agree to that, when it goes in front of a mediation, they may get the same interpretation as well, and that may be a problem. You may have to counter that to make it clearer. And a lot of the seasoned veterans know how to maneuver those and ultimately make sense. And it's just, again, a quick counteroffer saying, okay, I understand that this is what it means, but it should say this instead. And then usually you're good to go. With that, that completes our class. I'm long-winded today, so I appreciate it. Any questions?
Yeah, Simon, I have a comment.
Yes.
On the part where you said about loan contingency removal. The way I deal with my buying clients is I get an email from the lender guaranteeing that the loan will be approved. I always tell them, I tell my buyers, do not